We're very fortunate to have Barbara King here this afternoon to speak to us about evidence. Barbara is a partner in the Albany office of Tully Rinke, where she focuses her practice on family and matrimonial law. Barbara also works with domestic violence initiatives, assists legal project clinics, and provides indigent people her services and matrimonial clinics at no charge. For her commitment to the community, Barbara has received numerous awards, including the New York State Bar Association Pro Bono Award, the American Bar Association Difference Maker Award. She is a New York Law Journal Lawyers Who Lead by Example honoree, and she has conducted continuing legal education seminars and presentations for the New York State Bar Association and many other entities, including the Third Department's AFC training programs. And we're delighted to have her here for her first Fourth Department AFC training program this afternoon. Please help me welcome Barbara King. Thank you, Barbara.
I'm going to start out by apologizing. Some of you may have heard that there was a survey that came out about the worst accents in all the states. And so if my Long Island accent comes out, we ranked 50th. So I apologize. So I'm going to go over some issues of evidence, and I'm sure most of you practitioners are rather seasoned, and this may be some basic stuff for you, some overview. I'm going to do it, though, obviously with a focus on what the AFCs should be looking for and doing. And so evidence isn't the sexiest thing, but it is very important. And I'm doing it out of the context of a case out of the Third Department that Linda shared with me when she sent me the material, so I'm sure some of you are familiar with it. It was the matter of Payne. How many people were familiar with that decision? It had to do with the lack of appropriate representation by the AFC. I'm just going to highlight a few things about it because this really plays into why the evidence is so important and the discovery is. There was a case where in Broome County Family Court where the mother filed a petition to modify an order of visitation. And there was a consent underlying order, and she made the application to modify it. The child was 13 years old, and she wanted to completely eliminate the father's parenting time. So she was looking for some pretty steep relief. The father appeared at the initial appearance, but for some reason unknown did not appear at the fact-finding. So the only presentation at the fact-finding was the attorney for the mother, the AFC on behalf of the child. The court held a Lincoln hearing and then dismissed the mother's petition. So you would think, how could I lose an unopposed petition? Well, it happens to the best of people. The court decision goes on to talk about the standard of modifying an order of custody, which most of you know. And then an appellate attorney for the child appealed because apparently the child wanted the modification, and with the petition dismissed, it would not be modified. So the appellate attorney for the child, who was not the same trial attorney, argued that the record was not sufficiently developed to allow the family court to find that continued parenting time with the father was not in the child's best interest. And the trial attorney for the child did not provide effective representation. I'm going to talk a little bit more about this case, but the kernel here is, as an AFC, don't rely on the other attorneys to do the work. Don't rely on them. Even if your client, the child, say in a custody case, is aligned with dad, don't rely on dad's attorney to be doing the job, because some attorneys, A, don't know how to do the job, B, don't have the time, C, just don't bother. And no reason is excusable, but we all see it happening. The case went on to opine, the attorney for the child must zealously, as you know, advocate for the child's position. And where the child is capable of knowing voluntary and considered judgment must be directed by the wishes of the child, even if the attorney for the child believes the child wants something that's not in their best interest. We all know that. To this end, an attorney for the child in a custody case must take, and that's in quotes, must take an active role in the proceedings and help the child articulate his or her position in court. As such, an attorney for the child is expected and empowered to fully participate and advocate by all available means in presenting evidence on behalf of their client and is fully vested with the responsibility to present witnesses, testimony, evidence, et cetera, et cetera. Very strong language because apparently the attorney for the child did not do that. What the court did find was that during a short cross-examination, the AFC confirmed the nature of the father's text message to the child's adult brother, that he was involved in the child's life, but did nothing else, did not present any other evidence, any other testimony. So that was wholly insufficient. I suppose the attorney probably figured, well, Dad's not here to oppose this, Mom's got an attorney, and I'm just going to ride on the coattails. And it ended up in a very bad decision and being sent back to court. The good thing is it went back to the trial court, and so there was another bite at the apple. So that's the context in which I'm going to go through this stuff that most of you probably know very well already. Remember, family court is not a court of discovery as of right. You must, it is a summary, it's a special proceeding, so you don't just start serving all kinds of discovery and assume it will be complied with. Discovery is by permission of the court or consent of the parties. I have a brief definition. You all know what discovery is. CPLR 3101, there shall be full disclosure of all matters material and necessary in the prosecution or defense of the action, regardless of who bears the burden of proof. So this can include discovery on third parties or on persons not a party to the action if necessary. Some disclosure is mandatory, as you know, like in family court when you have a support case going on, there's mandatory things that you have to produce, but that is not so in other family court proceedings. So don't assume that, A, you can just serve demands, and also don't assume that you have to respond to demands if they are not by permission of court or consent of the attorneys. So if you get served with some demands, you need to look at them and decide, is this stuff my client wants me to turn over? Is it stuff I have to turn over? And do I agree to it or do I require the court to order it? Another thing I find that happens a lot with AFCs, let's take a typical custody case. Mom and dad are serving discovery demands on each other. How many people as AFCs find that they don't get copied on those discovery demands? Yeah, most. The attorneys just kind of forget you're there until they need you, and then they're on the phone, you know. But they often forget to do that. So take an affirmative stance the first time in court, and if discovery is discussed, make sure you state on the record, I want to be copied on all the discovery. One attorney may be demanding from the other something like your client's mental health records, and maybe you don't want your client's mental health records turned over. If you don't know that discovery demand has been made, you have no opportunity to object, move to quash, or preclude it. So make sure the attorneys are on notice. Or if you send out a standard introductory letter, which I know a lot of AFCs do once they get assigned, put something in the letter that says, please note that I expect to be copied on all discovery demands made between counsel. The other thing is, and I know you get your petitions all different ways. In Albany, a lot of the judges just throw them in a little cubby hole, and when the lawyer shows up, they say, oh, I got assigned to a case. Other times it comes in the mail. Other times, you know, many of us have gotten dragged out of the hallways of the court. Are you free? We need an attorney. So you don't always have time to really look at or understand what the case is about. But try as early as you can, just by reading through the petitions, to get a handle on what the key issues are going to be for your client. Think about your burdens of proof evidentiary-wise. Think about your theories early on, because my tip would be, even if in the first appearance, and I know the AFC is not always there at the first appearance. Sometimes they don't get appointed till after. Some judges, you get it in the mail with the initial petition. But at your first appearance, be sure to have reviewed all that and address immediately up front. Judge, I know I'm going to want some discovery in this case, or I'm concerned that there may be a request for certain records on behalf of my client that I might have an issue with. Get your judge's rules right up front. Judge, how do you want us to address that? My experience is the judges usually say, counsel, feel free to exchange discovery, but if there are objections, let the court know. I've had some judges say, send the court a copy of the discovery, and we'll look at it and decide if we have issues. But it's best to find out how your judge wants to handle it and get those rules early on. One of the attorneys in my office wanted to serve a subpoena for some records, and they just served the subpoena. And the other attorney objected, and the court sent a letter and said, hey, guys, there is motion practice required to do this, Neither side thought the court would want that. And we'll talk about that procedure for motion practice. But again, every judge has different rules, so the earliest point at which you can address those rules and identify what you think you might need or might want to object to is better. I'm going to run through, again, just some of the common tools. This may be very refreshing for most of you. You know all this, but whether you are demanding or answering, CPLR 3102. Witness demands. Maybe the attorneys aren't exchanging discovery at all. I've seen cases where they go to trial and nobody ever requested even witness lists from each other. You can do that. You might, you want to know who's going to come in. Maybe it's a JD case and you're defending a kid who's, being charged with something. You want to know. So whether it's custody or JD or even a neglect case, you can demand witnesses, eyewitnesses, character witnesses, any witness that might be called at trial. Certainly expert witness demands. Attorneys, generally, if they're going to call an expert, will have exchanged that information, but I see a lot of slipshod practice going on, particularly in family court. We were talking about how, people think family court's not necessarily a court where evidence matters. Well, it does. So find out about the expert witnesses and do a demand if you want, because as many of you know, at an expert witness demand, you have to give more than just a name. You have to give their curriculum vitae, if you have it, their background. You have to talk about what they're going to base their opinions on. The expected facts they're going to talk about, the expected opinions they're going to give. So it is a rather extensive disclosure for experts. Records, school records, medical records, counseling records, whatever you want. We'll talk about getting them certified later, but demand records. Maybe there's an issue that mom doesn't get the kid to school. All right, well, you're going to want to see the attendance records. Don't expect dad's attorney to ask for them. Make sure you, as I said, think through the issues in the petition after talking with your client and figure out what you need. Medical authorizations, the HIPAAs. Medically restricted records will not be turned over without a HIPAA. If you want your child's records, you'll need a parental consent to those child's records, unless the court will allow you. I've seen courts just allow the AFC request them on behalf of the child, but you'll need to get that cleared with the court. Again, think about whether or not your client does or does not want their counseling records turned over, because maybe we don't want mom to see what I've been in counseling complaining about. Go through that, and which is why if you're not copied on the demands between both sides, dad may have asked for them, and mom may have given them or authorized them, and you don't know that your client's records have been turned over. Here's a big one, social media. That is really the big thing. Folks are hanging themselves in court all the time with postings and texts and improper photographs. And, we've all had the case where, mom comes up with a picture of dad on Facebook where he's wearing, a array of bullets across his chest and two, I don't know, firearms, some kinds of firearms, right? Automatics. Look, he's a dangerous guy. Look what he posts on Facebook. But ask for that stuff early on. Social media, 3120 of the CPLR allows for discovery, production of documents, and things. I like that word, things. You rarely see the word things in a statute, but you're allowed to ask for things. I don't know what that is. Maybe it's an iPhone. You want to get a look at what's on the iPhone. Maybe it's a laptop. Things for testing, copying, or photographing. A legal hold letter, especially with social media stuff. New York Law Journal, May edition, did a really nice article on preserving evidence, electronic evidence. If you think your case is going to require somebody to turn over emails, text messages, social media postings, anything of that nature, send a hold letter to the attorneys early on. This is to put you on notice that we may be looking for this information. You are required to not delete, destroy, or manipulate the material pending discovery. You put an immediate hold notice out there to them. They're then obligated not to accidentally delete something. Interrogatories, I see this in cases with custody. As you probably know, under 3130, those are written questions answered under oath. People like them because they have to be sworn to under oath. You can then cross-examine somebody on their answers. But they're a great way of asking very detailed questions, and in addition to asking questions that have to be answered in writing, demanding the backup documentation. Have you ever been convicted of a DWI? If so, produce a copy of the notice of conviction. If you have a copy of the complaint, you can get records that way. The notice to admit, we call that the underdog, least used, most helpful, CPLR 3123, a great way simply to authenticate documents. You might be worried about getting something into evidence later on, but if I've got a Facebook posting that is helpful to my case and I can print it out, I can send it with a notice to admit to the other side and ask them to admit that this is a posting from their client's Facebook page from February 21st, 2018. And they will have to either admit or deny it. They have 20 days to admit the authenticity. If they don't, it's deemed admitted. If they deny it, then obviously you now know, okay, this is a hurdle I'm going to have to get over because I need this as evidence. I can now know to prepare for that when I go to trial, make sure I have my foundation laid, my proper witnesses. So anytime you're anticipating some evidentiary problems, think about whether or not you can't cut it off early with a notice to admit and make the rest of the process easier. There are also rights under 3121 to request physical or mental examination. You may be requiring one of the parents to have a mental health evaluation. Normally in family court, you just raise the issue while you're addressing things with the judge, and the judge can order it or the parties can agree to it. But you can send a written notice, ask for a hair follicle test if there's issues of drugs perhaps. So if you come in later in the case and you got appointed after the first appearance and you're not going to be back in court for 45 days, but you want to get a hair follicle test done because you don't want someone shaving their head or getting something out of their system, you want a blood test or urine test, consider serving one of these 3121 requests for examination. All right, objections to discovery. So there's some discovery either served on you or between the parties and you want to object. Once the discovery demands are served, and this process shifted, I think, about 10 years ago, where now the statute requires that the burden is on the party objecting to the demands to object within 20 days. So if you get served with discovery demands, you have only 20 days to send an objection if you think some or all of the demands are inappropriate. And you have to state why they're inappropriate, not just they're inappropriate. You have to say why. If you don't do it within the 20 days, you have waived that. By doing that, you have now shifted the burden to the demanding party to perhaps have to make a motion or go forward to try and get this evidence. I am very particular about what I call tasking. Anything that comes in the mail or goes out, there's a deadline on it, it goes on the calendar, on a task list, on something where I'm tickled every week and I can see, gee, I only have 4 days left. I forgot, I got to get that objection out, or I've got to make sure I serve these papers on time. So it's an old method. I'm sure everybody has their own way of doing it, but I can't overemphasize how important it is. All right, protective orders, 3103. Why might you seek one? Again, let's use the example, your client does not want their mental health records turned over. A court can, on its own accord, sua sponte, decide that it will not be turned over, but again, don't rely on that. If you know your client doesn't want them turned over, you may have to make a motion on behalf of your client and bring a formal motion in front of the court asking for, and it can do several things, just either denying that the documents or the information has to be turned over, limiting or conditioning it, or preventing, in order to prevent any unreasonable annoyance, expense, embarrassment, prejudice. So here's what a court can do. The court can either say you don't have to turn it over, or you do have to turn the information over, but only the last 12 months, not the last 4 years of records. They can limit the scope of it. They can order that the documents be sent in camera and looked at by the court in camera rather than given to everybody. They can allow certain parts of the records to be redacted if you give them a reason for why certain information should not be turned over. Or the court can simply deny the discovery request completely and say you don't have to turn it over at all. But you have different options. It doesn't have to be all one. It's either all in or all out. The court can also order the party making the demand to pay for the records. I had a case not to just March. We ended up in court on it in March. And the medical records, I think we totaled up, we spent about $890 on just copies of medical records. Well, you know, I'm sure the AFCs don't want to pay that out of pocket, and I'm sure that, you know, they don't want to get the bills for all of that. So you can ask the court to shift the burden of the cost of production to the demanding party. CPLR 3122A talks about certifying business records. If you are going to request records, if you request they be certified, you can probably get over the need to bring a custodian in at trial to identify them. I just love this. I don't know how many of you are familiar with the new CPLR section 4540A. I don't memorize numbers, so I don't expect anyone to know what that is, unless you're as excited about it as I am. This is great. This new section, and this is as of January this year, it establishes a method for authenticating a document, a digital record, so it could be a recording or a video, or other tangible property, namely by showing that the item was produced by the opposing party and has been created by the opposing party in response to discovery. So if I say, I want you to turn over copies of any and all text messages you intend to prove your case, which I can do, and the other side gives me 20 text messages and I want to introduce them at trial, I can, because the other side produced them in response to my discovery as their authentic documents. And now if they want to keep it out, it shifts the burden to them to keep the documents out. So basically, if you're going to turn it over, the assumption is, think about this also if you're turning over documents. The assumption is that whatever you're producing or is being produced to you is going to be foundational at trial. The other side should be able to get it in. So what are you going to say? No, Judge, you can't admit it because that's really not the text messages, or I edited it before I sent it. Yeah, you look pretty bad. So remember that number. I'm going to get my first tattoo, 4540-A. The effect of refusal to comply with discovery. CPLR 3126 has a wide range of what can be done if a party fails to comply. So you demand discovery from one of the other parties, and they just won't respond, or they will only partially respond. You can make a motion to the court for the court to render some kind of penalty for failure to disclose. And here's what the court can do. Again, it's got a lot of options. The court can rule that if you're not going to turn the item over, then you can't use it at trial, right? So if I demanded medical records of the mother, mental health records, and she won't produce them, she can't rely on them at trial. I'm going to stop here and just say conversely, again, think of it on both sides. If you're asked to produce something in discovery and you don't produce it, the same effect is going to be on you, that you cannot use it at trial. So they can do that. They can say, look, case goes forward, but the party just can't bring it in. They can decide a legal issue that turns on that piece of evidence in favor of the demanding party. So if there was a legal issue that this particular thing that I demanded would help determine one way or the other, and the other side won't turn it over, the court can say, good, then I'm going to decide that issue in your favor. They can, and this is the most draconian thing, they can outright dismiss a cause of action. They try not to do that. That is like I said, the most draconian thing. Generally, we all know the courts issue conditional orders. You're familiar with those? All right, Barb, you didn't turn the documents over. You're a bad girl. You got 30 days, turn them over. It's a conditional order. If you don't turn them over in 30 days, then here's the penalty. So they get you an extra bite at the apple. Sometimes the bringing the motion is just simply to get a conditional order. And then the last disclosure section I want to mention just very briefly because just because of the cost and time involved in it, we don't tend to do them very much in family court or depositions, 3107 through 3117. There's a whole 17 sections, 10 sections, dedicated just to depositions, how to hold them, how to notice them, how to record them, etc. One of the attorneys I work with loves to video record all the depositions that he does because he just feels that it somewhat intimidates the other side. But there's an expense to it. So, and I'm not sure if that gets paid for by the panel.
I can tell you it's very unusual for a state request. The one time I can think of it's happened in the past 6.5 years I've been with the program, was a situation in which the AFC felt that whichever party it was that they were aligned with, that person wasn't going to do a very good job proving the case, kind of like a matter of pain situation.
Right.
So they wanted to have a deposition, and in that case, we did agree to pay for the transcriptionist.
Good. And that's good to know. So if you have a situation where, like I said, the Payne's a great illustrative case. The other side just didn't carry their water. So you can explain that to the panel, and they'll certainly help. All right, I'm going to shift now briefly to Article 23 of the CPLR because that talks about subpoenas. When are they needed and how are they used? 2301 talks about the authority to issue subpoenas, which basically we're talking four categories, two of which are overlap. There's subpoenas that require court authority and subpoenas that don't. There are document subpoenas and witness subpoenas. So the document subpoenas and witness subpoenas can fall under the category of what the court must order and what the attorney can simply issue a subpoena for on their own. So obviously the trial or witness subpoena requires the attendance of a person to give testimony and or produce books or records or things at the trial. So you want the neighbor to testify because the neighbor was a witness to dad locking the kid out of the house in 2 feet of snow and leaving him there for 3 hours. You might want to serve a subpoena. Now, that may also be a willing witness. They'll come in. You don't really have to subpoena them. Even with willing witnesses, I like to serve a subpoena anyway. It makes it look a little bit more sanitized, and sometimes the witnesses want to be able to say, well, I was subpoenaed. I had no choice when they see the neighbor over the fence the next day. And then, of course, you have the ducus tecum, or document subpoenas, to produce. That is not to be a witness, but just to produce records or other things. You want your client's school records, so you have to get them from the school. So let's talk about subpoenas that need to be issued judicially, judicial subpoenas. 2307 of the CPLR talks about them. Those are subpoenas you're going to serve on any kind of a municipality. If it's a state or county hospital, the police department, CPS, a school, those are commonly what we would want subpoenas for. You want the police to produce records, CPS to produce all of their notes. These are going to require a judge to sign them. If you serve a subpoena without a judicial signature, they don't have to comply with it. Again, what is your judge's procedure? There are some judges, if you bring it up during an appearance, I know, Judge, I'm going to want to subpoena CPS's records, they'll say, good, okay, don't worry, just submit the subpoena to me. If not, you must bring a motion.
I have a question with reference to the trial/witness subpoena and/or to produce when it. Some judges will say if you want the 2307 person there, in addition to the documents, you as the attorney have to execute the personal subpoena yourself. The court, will execute for the documents. A lot of times I get calls from school and hospital attorneys and other municipal attorneys who will say, well, the personal subpoena is no good. The judge needs to sign it. But the judge will say, I don't want to sign it. That's up to you to sign it. How do you handle that?
Good. That is in my tips section, and it's a very good question. When I have to serve a subpoena, I just had to serve one on the city of Schenectady, on the police department, and then I had to serve one on the New York State New York State local retirement system, and they were both judicial subpoenas. We call ahead. We call ahead, and we talk to someone in the legal department or corporate counsel or whoever is in charge. And we just ask them. I play the golly gee thing on the phone. Golly, I got to serve the subpoena. Gee, how do you do it? Could you direct me? And most times they're very, very helpful. Reason I was going to talk about this as a tip is some of them will even say, just fax it to us. The retirement system didn't want to check because you have to reimburse them if they have to travel or reimburse them for the cost of records. They said, no, just fax it over. The city wanted it personally delivered. The city wanted their check. So I call ahead and try and get that information. And then if they say to me, both the subpoena and the witness attendance subpoena must be signed by a judge, then if I have to make a motion, I can tell the judge in an affirmation, Judge, I called, I spoke to Joe Smith. He told me they will not honor it unless you sign it. Okay, so that's a good procedural question because it's all these little bumps you run into along the way that send you chasing rabbits, and it should be a lot easier, but it's not. Okay. Note, a subpoena for mental health or medical records. If you get a judge to sign one, or it's not to a municipal hospital, or it's to a private social worker, and you can just send your own subpoena, they should not be complied with unless accompanied by a HIPAA release signed by the patient. If they do comply, and I have seen hospitals, I did see a doctor's office reply to a subpoena without a HIPAA, and then they ended up getting charged with violation of the HIPAA rules, the doctor's office. So if you're serving a subpoena for anything that requires a HIPAA authorization, even if it's signed by a judge, they should not produce the records unless accompanied by a HIPAA. Now, what happens if the person whose records you're trying to get, mom's records, mom or her attorney will not allow her to sign a HIPAA release? Well, serve your subpoena anyway. It's going to get rejected, but at least you can approach the court and say, Judge, I requested the HIPAA. They wouldn't turn it over. Now, what can the court do? The most the court can do, they cannot, my understanding is, and if any of you had a judge do this, please tell me, but my judges have told us, we cannot and will not make a person sign a HIPAA release. What we will do is we will take a negative inference for their failure to do it. Has anyone run into that? Okay, so basically they should not be turned over. So do not expect them if you don't have the HIPAA. Okay. Note the directed service requirements under CPLR 2306. You have to give at least 3 days notice on a subpoena. So if you want records in less than 3 days, unless you've got an order to show cause that goes with it, they don't have to comply in less than 3 days. I had a case in court 2 weeks ago. It was they were to produce the records for the 9 o'clock court appearance, and the records weren't there. And we called later that day to find out what's going on, and they said, oh, we delivered them, they're there. Well, they delivered them at 4 o'clock, which wasn't any good because we were in court at 9 o'clock. And we did give them plenty of notice. So make sure you give that notice in advance. Service costs and fees, 2303 and 2303A. Serve it like a summons. Basic CPLR service. Make sure if you're serving on a municipality that you serve the right entity. If it's a subpoena on the state, depending on what agency it is, you may have to serve the AG's office. You may have to serve, if it's a city, corporate counsel. So like I said, call ahead, but there are specific requirements of who gets served if they are judicial subpoenas against municipalities. And there are fees and travel costs, and I don't recollect what the mileage is right now, but if someone's going to have to come to court, you can just Google it, X cents per mile, and you have to reimburse them for that, and then the subpoena fee. So when you call, just say, who is your designated agent for service? That's probably the best question to ask them. Oh, also, I strongly recommend you file an affidavit of service with the court that you served the subpoena. Make sure you file that. It's one of the things where, you know, if you don't do it, no big whoop, nothing comes up, but if the records don't show up or the agency says we never got them, you have an affidavit of service. If I serve something personally, I ask for a business card from the person that I left the papers with. Now, where they're returnable, let me back up a moment before I talk about returnable. A few basic subpoena rules you probably know. If you are sending a subpoena to the court for service without a motion, the judge said just send it to me, copy your opponent or any other attorney in the case at the same time. They need to know that you're sending this. Give them an opportunity to object or make a motion to quash or limit the subpoena if they want to. If you are serving one that is a non-judicial subpoena, You must send it to opposing counsel or any attorneys on the case at or about the time you're serving it. So I try to send it in advance. It should never be a surprise. I am shocked how many times I get notice that records came in on a subpoena that my opponent served, and I never got the subpoena. I didn't even know about it till the clerk said the records were in. So make sure you don't break that rule. All right, and where are they returnable? Little known rule. If the subpoena is returnable, the records are returnable to the court, sometimes it'll say, have them at 9 o'clock in front of Judge Smith at Schenectady Family Court, then you don't have to produce copies of those because they're returnable to the court. Sometimes, like the New York State Retirement System sent me a courtesy copy. My subpoena asked them to produce the records to the courthouse, but they sent me a courtesy copy. The fact that they sent me a courtesy copy did not mean I now had to send a copy to my opponent. The opponent knew they were returnable to the court. The opponent has to get off their tail and go to the court and get them. I sent a courtesy copy anyway, but you don't have to. If, however, the records are returnable to your office, then you must produce a copy to all attorneys. So don't forget that. As I said, putting them on notice gives them an opportunity to make a motion to quash or limit the subpoena if they want to. They can seek a protective order. If they can establish, and I have a sample subpoena and motion here for you, I just want to direct your attention to. The material sought must be necessary and not unduly prejudicial. So I just want to show you very quickly. There is an order to show cause here, which is blanked out so you can fill it in, seeking records from a city police department. And then the attorney affirmation in support argues why they are material and necessary.
Are you able in one subpoena to put both returnable to the court and to your own office?
Yeah, I don't see why you can't.
Okay.
I've not done that, but I don't see why you can't. Or alternatively, you can serve just two subpoenas. One says returnable to the court. Although, you know what, I would put it in one if I was going to do it because papers get separated and people get confused and they think you sent them two different things. And I know I get confused, so make it simple. And, often I will also send a courtesy cover letter, something nice along with it. Gee, thank you for your cooperation. If you could send a copy to us. People just like being treated like they're human, especially if you work in a government office and you're dealing with a government office. So this is just a very simple, straightforward affirmation by the attorney as to why the records sought are material, probative, necessary, not unduly prejudicial, and you can mock them up for whatever kind of case that you have. All right. One other thing I did want to mention. We talked briefly about expert witnesses. If you're dealing in a case where there is an expert witness and you are going to subpoena their records or you're going to subpoena the expert witness to court, demand their entire record, not just their expert report. Demand all the underlying notes, copies of every document that they looked at in preparing their report. I had a trial in 2017 where I demanded the expert's entire record, and she came in she had a lot. This woman was a really good expert. She worked hard. And she had done a custody evaluation, forensic. So I represented the dad, and she had done the neutral. And so I had not seen everything the mother and the mother's attorney had given her because I hadn't had time to go to her office and review the full file. So during the trial, I was digging through the records she brought in, and I found a really damaging email that helped my client. It was the mother calling my client all sorts of horrible names and downing him as a father. It was just really a horrible, horrible email. It was great because she brought the whole file, and that wasn't because I was smart, I just happened to stumble on it. The best thing, of course, is to go and look at the records yourself. But if you're going to subpoena it, ask them to bring their entire file with them. Okay. I'm going to talk, we go till 2:15. Okay. So I'm going to talk about preparing witnesses. If you're representing a kid, mostly that child is just going to be in camera in a Lincoln hearing. Has anyone ever put one of their own child clients on the stand? Yes, maybe it was a JD case? What was it, JD? Yeah. Anyone else? Yeah, to testify. Yeah, I just briefly want to know under what circumstances you may have done
In a
that.
JD case.
Okay.
Mine was custody. Jen's coming on your side.
Mine was a custody child sexual abuse case.
And how old was your client?
15.
15. Okay, thank you. I'm thinking I've only done one custody case where the other side put a child on, but it's because it also had an abuse component to it. So generally, we don't put our clients on the stand. I'm going to talk about preparing witnesses. This probably doesn't apply so much to putting kids on the stand as witnesses that you're calling for your case, perhaps your expert or your witnesses to buttress your kid's position. So, okay. Again, I'm sure you folks have gone through this with clients over the years, but I'm just going to boom, 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 go down a few tips and highlights. I do very aggressive questioning of a potential witness, and I tell them right up front, I said, this is not the warm and fuzzy me. I'm going to be really, I'm going to be a devil's advocate here, and I tell them that. And I probe, and I go down rabbit holes, and if they say something that is not ringing, I'm going to chase it, and I'm going to spend a couple of hours with that person, depending on how long they're going to testify, because I want to probe everything and not have a weakness come out. I had a client testifying at a deposition, and they were asking him about affairs. It was a very angry ex-wife, and she sued for adultery. It's ridiculous, with no fault. But they just wanted to depose this guy and make him squirm. So the attorney says to my client, so did you have any other affairs? And my client goes, affairs? No. But the way he said affairs, right? You all laugh because it tells you something else is under there. So then the other attorney knew, okay, well, what would you call them? What were they and what would you call them? Then he had to come out with everything. Well, one night stand's not an affair, and meeting in the hotel for an hour is not an affair, and then forget it. It was just a mess. So now's your time to really probe and catch all those idiosyncrasies if you can. Find the skeletons. You tell them, now is the time to tell me. Tell me. I can't protect you if you don't tell me. What is the worst thing you wouldn't want your mother to know you did? And get it out and get in front of it. I do a sample direct and cross-examination. I actually do a cross with the witness and probe them even harder and play the devil's advocate. And then I teach them what I call the 3-count rule. When you prepare, don't just prepare them for direct, prepare them for cross. And on cross, I have the 3-count rule. And the 3-count rule is I tell them because I'm not very smart. I'm not fast, right? I think slow and deep, not fast. If you're asked a question on cross-examination, count to 3 before you answer it. That gives me time to process and think if I want to object. If you answer right away on cross, I can't think, I can't process. So I find it helpful to give them, but not a Southern 3-count rule, not a 1, 2, a Long Island 3-count, 1, 2, 3, right? Get them somewhere in between. Don't over-rehearse them. I find if I over-prepare them, they get nervous, but do prepare them. It has to be their testimony, not you telling them what to do. There was a whole article last year in the New York Law Journal about over-preparing witnesses and when you cross the line between coaching. That was very revealing. Explain the procedure to them. Explain what direct is, what cross is. I say direct is friendly fire, cross is enemy fire. Explain to them what the objections are. They don't know the difference between sustained and overruled. And sometimes when I'm in the heat of a trial, I forget. And the judge will say overruled, and I'll say to my client, oh, you can answer, right? So we all get stuck in those points where we're too keyed up. So explain the basics to them. Explain redirect. I find that most people are nervous testifying because their attorney never explained to them, I get to come back after cross and re-question you. While you're testifying on cross, guess what I'm doing? I'm making notes. And I'm using those notes so I can go back. So if you answered a question and the answer came out horrible, instead of you getting stuck on what you just said, that the next 20 minutes you sounded like a babbling idiot, don't. Because I'm making notes, and I'm going to come back, and I'm going to help repair that. Telling them that redirect is there really puts them at ease. Warn them that the other attorney may call them also. Sometimes witnesses are on both lists. They're really my witness, but the other side put them down. I am the respondent, so I'm going to go second. Well, you know the old trick. Call your opponent's witness first. That catches them off guard. They're probably not ready. You know, the lawyers that go to court, yeah, we're on trial today, but it's only half a day, and we're the respondent, so don't worry. The fact that we're not ready, you're not going to testify. And then a smart lawyer calls them to the stand as their first witness, and then the case is over. So prepare them for that, too. Have them use simplified language, and the biggest rule is don't fence. Do not fence. Tell them don't fence with the attorney. They have done this 1,000 times. You have not. So don't get into a fight with them.
If you call them, though, as your witness, you can't lead them, correct?
Right. You can't impeach them, and you can't lead them unless they become a adverse witness. They start fencing and get really difficult. Then you can ask permission to treat them as an adverse witness.
But it's I would think it's dangerous in many instances.
Yeah.
To
Anytime
take that
I've done it maybe to ask like 3 questions where I knew what the answer was going to be because I wanted that issue up front. I wanted the judge to hear that right away. Otherwise, I don't typically do it. But you're right. You can't lead them unless they become confrontational, and you can't impeach them because by calling them as a witness, you're vouching for their credibility. That's a good point. Especially experts, if you're going to be using an expert, simplify it. I tell experts the theory that wins isn't always the theory that's right. It's the theory that the judge gets. So have them simplify it as best as possible. Get the bad stuff up front, obviously. Have your client own it or have the witness own it. If you're the neighbor witness to the kid being left out in the snow, also happens to be on the sex offender list, get it out there, right? Because that sounds worse on cross than it does if yes, I'm a sex offender, but I would never leave a child out in the cold. Have your witness have some positives to say, particularly in a custody fight. For the most part, other than Charles Manson, people aren't all good or all bad, right? I mean, we generally fall somewhere in between. So, my next door neighbor isn't the neighbor from hell. She did bring me over some soup when I was sick once. Get them to say something nice. It makes the testimony more credible. As you're preparing your witness, watch their body language. Those of you that play poker know people have tells. Well, witnesses have tells. And you know when they're lying or they're getting anxious or they're twisting the truth a little bit. So watch your witnesses' habits and prepare them. So, every time you say something mean about the father, I notice you tug on your ear. I know, something. But watch for that and try and break them of it. And I also tell them, you know what? Don't feel afraid as you testify to say, I'm nervous. Judges expect it. They know it. I'm just nervous. I've never done this before. It humanizes them and connects them. Watch the judge. Are they taking notes? Are they looking at your client? What kind of face are they making? Are they looking at the other attorney and the other attorney's client? Or are they looking at Facebook? Have some idea of just how connected your judge is. And remind the client the judge is going to watch them. Not to make them nervous, but I always like to have a witness occasionally turn to the judge and answer a question directly. Even if the judge doesn't ask a question, I sometimes like them to turn to the judge as they explain something, and it helps connect them. And prepare them that the judge may ask questions. Then also, if it's a client who is, if you have a client sitting with you at the attorney's table during a trial, maybe it is a JD. This drives me nuts, but you're going through the testimony of the other side, and your client is next to you yanking on your sleeve and kicking you under the table and scribbling notes in front of you, and the judge sees all this hectic behavior, and you can't concentrate because they're yanking on your coat. I give my client a pad and a piece of paper, and I say, just write. Don't make faces. Don't tug at me. Don't kick me. Don't scribble and throw it in front of me, just write. And then I'll look at the notes, and I can review them, and don't write idiot. That gives me no information at all. you know, give me something of substance. So that just gives them something to do, keeps them calm, and helps the case go. Before I'm going to get into talking about introducing records, I do want to mention I was at a CLE lecture recently. Most of you know Professor Mike Hutter from Albany. He's done a lot on evidence over the years. They're close to finishing. They are 90% done putting together a set of evidentiary rules for New York State. Can we get a hand? New York State does not have its own set of evidentiary rules. They have been working on this for several years. It is 90% done. They expect it to be completed by September. I am going to give you the website. And you can want people to start using this website now to access the evidentiary rules. Pens ready? It is www.nycourts.gov/judges, all in caps, /lowercase evidence. newyorkcourts.gov/judges/evidence. So hopefully it will be done later this fall, and we will now have a set of New York evidentiary rules. They couldn't get the legislature to do it, so the courts are doing it. Okay. Introducing records, getting documents into evidence and keeping evidence out. The basics. Go back and know what you need to prove your case. What do you need to make sure it gets in? What do you need to try and keep out? If you've done your discovery, you know what you have. You've limited the issues where you're going to have trouble getting something in or keeping it out. Under the 4540A rule, if the other side or any of the other attorneys have produced discovery in response to demands, you're going to have a much easier time getting those in. If you've done notices to admit for documents that you want authenticated, photographs, you can authenticate photographs with the notice to admit, contracts, text messages, social media, just about anything. So you now know what you're going to be able to get in easily, and then you can cull it down to what you might have problems with. Stipulate to enter exhibits subject to cross. There is nothing wrong with contacting all the attorneys and saying, I do this all the time, give me a list of the exhibits you want to put in. I'll send you my list. We'll go through it. If we can agree to 100%, great. If we can agree to 90%, great. If we can only agree to 10%. Anything we can agree to, we've culled it down so the trial can go quicker. The judges love when you do that. And it prepares you for what you're going to have to fight to get in or keep out. So do that. It's subject to cross. So just because you're stipulating that it goes into evidence doesn't mean you can't still cross-examine regarding that particular exhibit. You know, when you wrote this email, you know, we know you wrote it, you produced it, it's in evidence, but when you wrote it, tell me what was going on. Tell me what you meant by this word. So you can still go into cross-examining the document, but you've made the litigation much easier. Work with the attorneys to make everyone's job easier, make the judge's job easier. I'm sure most of you do this. Pre-mark your exhibits if you can. The stenos love it in family court. The clerks do it because we don't have, right? No one's got stenos anymore in family court, right? Do you? I'm moving to Madison County. Seneca? That's nice. Certain cases. Yeah, because those recordings are horrible. They're just horrible. Plus, I hate hearing myself. But yeah, good. When I started practicing, I'm not that old, but I did do a deposition where a woman took it in Greg's shorthand. That was something. She was good. So pre-mark them if you can. This will, again, allow you to plan for what documents you're going to have to get in. It'll help you do your research to prepare to get them in. It'll help you make sure that you have all the witnesses you need to authenticate and get those documents in. The other side wouldn't allow certain photographs in. Well, now, if I want to get them in evidence, I have to bring in the person who took the photograph. And maybe it wasn't my client. Maybe it was my client's cousin who lives in Nebraska. So I have to think about how I'm going to handle that. Your notice to admit, again, may have overcome some of those issues. Subpoenaed documents, if they're in and they're certified, you don't need to bring the custodian, so you don't have to bring the local county clerk in to say, yes, these are our records. You've gotten over, if you've done your discovery well, you've gotten over a lot of these issues about introducing documents. And know what battles to fight. We had an attorney in Albany. He was a really good trial lawyer. And one thing I loved about him was he would stipulate to anything. He would let you put anything in evidence because he figured, whatever it is, I can cross-examine. I mean, unless it's really, really, really damaging. It's just like, I'll let anything in. And he was a very good lawyer, and it was a smart tactic. But know what battles to fight. Don't object to everything just because you can. It may not ride well with the judge, and it may not move your case along. You're going to be in front of this judge again. You're going to deal with this lawyer again. So, try and be civil. I have some attached sample questions for getting in common exhibits such as photographs, texts, social media recordings, and videos. You can use and reference those as you want. I think I did want to mention one thing about them. One is just the basic elements for getting these things in, and then a set of sample questions. So if you look at this early on and you know this is what I'm going to have to do to get this evidence in, then I know I'm going to have to disclose certain witnesses to get this evidence in. If I know I need the aunt from Nebraska to get the photographs in, but I didn't produce her on the witness list, it may now be too late. So it's a good thing to review. It's like people that do a lot of civil litigation. You read the pattern jury instructions first before you sue your case because you want to know what the jury has to decide before you even draft your pleadings, right? That was always the smart way to do things. So do your cases backward also. Okay, voir dire. I want to talk a little bit about voir diring of experts. If you could, by show of hands, how many of you had to voir dire, question an expert who was being brought in? Okay, it happens a lot. Yeah, it does. It happens a lot. When to do it, why to do it, and how to do it. Voir dire is basically questioning the qualifications of the witness before they are allowed to be deemed an expert. Why do you want to do this? Or why do we want to qualify them? We want to qualify them because an expert gets to do something that I like to do all the time, but I can't. I give their opinion. They get to give their opinion. Other witnesses cannot give opinion. So you have to qualify them. So when do you want to do it? Well, it depends on whose expert it is, if you agree or disagree with their position. If their position is going to support what your client wants, the child wants, or not. If you agree with them coming in, or it's your witness, you may not have to voir dire them. If my opponent is introducing an expert and I agree, this is an expert, they can testify, because we're not disagreeing on what they're testifying to. We're just disagreeing on their expertise to give an opinion on a certain thing. But if you agree with them, you can just say, fine, I don't need to voir dire, and let them in. If you disagree with them, you're going to want to voir dire for a couple of reasons. All right. Joe Smith is an expert psychologist in child forensic. That's what he does. He's done it for 30 years. The court has known him for 30 years. He's been upheld in the appellate division for 30 years. He walks on water. Why would I want to voir dire this guy? Well, what if the appellate division didn't know him? What if the judge I was in front of didn't know him? What if he's an expert in child custody, but the issues of this case involve eating disorders? And he has no background in that. He has no training in that. He's never written an article in that. He doesn't counsel kids in that. I may want to voir dire to hit on the weaknesses of where he's going to be giving his testimony. At the very least, get the curriculum vitae in evidence. So if you're bringing an expert in and the other side says, yeah, I don't want to hear how great Joe is. I don't want to hear that, he's the second coming. Just let him in. At least get the CV in. Because, again, you don't know if the judges on the appellate division know this person either. All right. And even though this doesn't come in a voir dire, certainly if you disagree with an expert who's been qualified, you can always ask the typical questions during the trial, like, how much were you paid? How often do you testify? Make them look like a hack. Now, I did a lecture on experts in the third department, and the judges did things a little different in the third department. They're kind of split, so I don't know how your judges do it here. When you're bringing an expert in and you're qualifying them at the front, you're getting all their credentials in, the other side has questioned them, do your judges decide to allow them to testify as an expert before they start their testimony, or do your judges wait until all the testimony is in, the opinion is given? I had always, and I started practicing downstate, our judges always would qualify on the front end. You know, here's all my experience, here's all the books I've written, here's all my education, I've done this 900 times, judge, you know me, we had beers last week, you know, we talked about this. Yeah, they're an expert, we know what they're in. I had a judge who told me that in his area, they wait until all the testimony is in, even the opinion, and then they rule on it. And he had some very, valid reasons for it. He said he wanted to hear how the thoughts unfolded and how they connected it. And it seemed odd to me, but okay. All right, well, then we'll just keep doing it our way. Yeah, why put all that on the record? I'm going to touch on motions and eliminate at the end. Yeah. Anyway, I was just curious because it sounded odd to me. We had never done it. So we're just all going to keep doing it the same way up here, right? Unless someone tells us we're wrong. Okay. And then I have a sample voir dire attached. Questions to qualify your expert, to put them in. The general areas of inquiry that you're going to want to look into, and then specific questions. I also like to add how they're being paid, and I always like to, as I said, subpoena any witness I have, so it makes them look a little bit neutral, even if my client paid for them. But get it up front. Who paid you? How were you paid? How much were you paid? When were you paid? It's no mystery. They deserve, and judges know they deserve to get paid, but the other side, likes to say it with a sneer. Oh, $4,000? It sounds awful then. All right, trial objections. We're got about 15 minutes, so we're good. Okay. Again, stuff you guys know, just going to run through and hit on the highlights. The case of Heather B. versus Daniel B., I'm sure most of you are familiar with this because hearsay is our most common trial objection. And this particular case, as you know, said that in a custody case, the parties cannot testify to what a child said, but a child's out-of-court statements are admissible in a custody dispute if statements made relate to abuse or neglect and are corroborated by some other evidence. So ordinarily during a custody trial, the mother can't get on the stand and say, well, Joey said that his daddy girlfriend yelled at him or something. That's hearsay. She's saying an out-of-court statement made by someone who is not a party to the action. But if these statements, again, involve any kind of abuse or neglect and you have something else to corroborate it, that will be allowed in. Yes.
I'm currently in a trial now, and they have the expert witness on the stand testifying to the statements of the child in a particular circumstance. And that same witness testifying to other circumstances, again, stated by the child. So two separate ones, not corroboration, is it?
Is the expert testifying to what the child told them? Is it a forensic expert?
Just a mental health therapist that's
the kid's
qualified
therapist.
as an expert, yes,
Okay.
the child's.
And this is the kid's therapist?
Yes.
And the kid's therapist is telling the court what the kid told
Yes.
them?
But they're trying to state that if the therapist says there were two different instances
Right.
of whatever the
Right.
child was saying,
Right.
that it's corroboration through the same witness.
Yeah, I think it could
Could-
be. I think
could
it
be.
So the only statements of the kid came in through this one witness?
Yes.
But on two different occasions?
Yes.
Oh, I see what you're saying. Okay. That's a very good question. I would think you'd have to have a different witness as opposed to one witness but two separate statements. That's my gut reaction. I don't know how has the judge ruled on it?
Going trial with the matter, but
Yeah.
and that's all a part of research at this point.
Yeah, and judicial discretion, right? But if you object to it, put your objection on the record. Preserve it for appeal. So hearsay, again, you all know the typical hearsay. The police, your client testifies, when the police arrived, they told me my wife was drunk. Well, that's hearsay because you can't say what the cop said. If it's offered to prove that she was drunk, it's hearsay. If it was offered to prove the cop can speak, that's not hearsay, but probably not something you're going to need to prove. Okay, so your basic objections, compound questions. Did you steal the car and then rob the bank? Compound question.
Back to that question on the therapist, could you argue alternatively that it comes in not for the truth of it, but because it was said, and that formed the basis of the treatment recommendations that the therapist
or the
was
opinion,
following?
or the opinion of the
Yes.
therapist. Yeah, I think it could come in for that reason. Why did you choose this course of therapy? Why did you recommend therapeutic supervised visitation? Yeah. Of course, argumentative. So you enjoyed beating him up, didn't you? Argumentative question. Leading. You meant to hurt your cousin, didn't you? Assuming facts and evidence. We all know, when did you stop beating your wife? That question. Asked and answered. That kind of dovetails with argumentative. I get accused of asked and answered, but that's just because I can't remember, and so I ask the same question. But sometimes lawyers re-ask questions because they think they're going to get a different answer the second or third time. But it does get repetitive, and you can object. Speculation. When I saw him, he was high. Well, that's speculation, right? That you can say that his eyes were glassy, he was, stumbling, he was eating a bag of Doritos really fast, but you can't make a conclusion. Relevance. Anything that's just not relevant to the case. Do you like Star Wars? Probably not relevant. And then, of course, privilege. What did your attorney tell you? What did your doctor tell you? Unless the privilege was waived for the medical or therapeutic information, it would be privileged. Okay. So let's run through objections. Objections to evidence. And now that you have your key into the new evidence rules, you'll be able to do this. Failure to lay a proper foundation. The whole purpose of what I've been trying to talk about today is to avoid you running into this problem of inability to lay a proper foundation. If you have done your discovery, given it, demanded it, done notices, followed the 4540A rule, you may not have a problem with failure to lay a foundation. The other side might if they're not paying attention. So know when and if you want to use this, not just to protect and get your stuff in, but to keep other stuff out. Failure to lay a proper foundation or authenticate documents or evidence will keep it out. The lack of authentication goes along with foundation. You can't show that this recording was original. If you read through the sample questions I have about getting in a recording, what recording machine did you use? Had you ever used it before? Did you test it before you used it? Did you play it back after you used it? Has it been in anyone else's possession? Chain of custody issues. So if authentication can't be laid, you can keep evidence out. Relevance, again, if it has no relationship to the issues in the case. Inflammatory, it's more prejudicial than probative. You're representing a JD, and she's been suspended from school, and she's in trouble with other kids, and I have no idea why kids do this, but they take selfies of themselves naked. I'm not sure you're gonna. If someone tries to introduce a naked picture of your 12-year-old client, I think you can object to that. I mean, the court understands what that is. They don't need to see that or put that in evidence. But it happens a lot, unfortunately. So think about what may be more prejudicial than probative. And, of course, privileged information. Unless it was waived, it stays out. All right, offers of proof. We're doing good on time. If the court has sustained an objection and you disagree, and so offers of proof can go either way. You can make an offer of proof because the court overruled an objection you made, or sustained an objection the other side made. In any event, you disagree with the court's ruling. Consider making an offer of proof, where you simply make an argument to the bench as to what you're trying to prove, why you're trying to prove it. This often happens when someone starts testifying to something that doesn't sound relevant, and your opponent objects it's not relevant. You're going to want to make an offer of proof that you're going to tie that testimony in later on to other evidence or other testimony. If you don't make that offer of proof, the court may sustain an objection, and then you can't get it in. I also think offers of proof are great because if a judge overrules an objection you make, you can put on the record for the appellate courts what the basis of that objection is, with a lot more detail. Objecting. Why to object, why not to object, and how. If the evidence doesn't harm your case, someone asks a leading question, but it doesn't harm your case, or it's just moving the testimony along, don't object. It drives me crazy when someone goes through this long line of questioning and object. It's a young attorney. They don't know how to question someone they're leading. It's not hurting your case. Let it go, because it's just going to become exhausting. And you don't want that to be the classroom for the attorney. You want to get your case moved along. But certainly, if it harms you, you're going to have to object. This is why you don't want your client frantically tugging on your sleeve or looking anxious when some piece of evidence comes in that's harmful to them, because right away, the judge is watching this. We all know that the appellate courts leave a lot of the credibility decision-making to the trial courts, because they could see the witnesses, hear them, watch them. It's not just the person on the stand they're looking at. They're looking at the people at the attorneys' tables also. So, they say never let them see you sweat. Tell your client that. And if there's an objection, I object. I vigorously object. I really, really vigorously object. Right? Just object. Again, preserve your issues on appeal. Put the basis of the objection on the record. There are many judges who say, I object. Before you even say why you object, they will sustain. They sustain, you just sit down and don't worry about it. But try and put the reason on. Objection, Your Honor, hearsay. Objection, Your argumentative. Get it out right there, because the appellate court's going to need to see the basis for that objection. If you don't know the basis, but you just say, I just know I should object, then just object. It's the best you can do, right? And then you'll be like me. You get the luck where the judge says, and what's the basis for that? And then you're like, I was counting on you, Judge. You tell me. So remember, the objection could draw more attention to the issue than you want, and you don't want to signal the other side. And some people, I'll admit I've done this once or twice, but it's really probably something we shouldn't do. But sometimes if there's a really nervous witness on the stand, we object just because we know they're coming unraveled, and we want to object just to watch them unravel because it helps our case for some reason. So it's not something just done, to be difficult, but if you see this witness is really having trouble, then do object to things even if they don't harm your case, because they're beginning to draw that witness out, and that's going to help you. Okay, preserving issues for appeal. We've really covered most of them already. Be prepared when you review your case at the very beginning to start issue spotting what may become appellate matters. Know your opponent. There are some lawyers we know they're going to appeal no matter what, unless they win. So that's usually a tell. We already mentioned the appellate courts may not know the experts, so make sure you get in their background. Make sure the basis of your objections are stated on the record, and you have made offers of proof. And with the few minutes I have left, I do want to touch briefly on what this young lady mentioned here, motions in limine, because not a lot of people use them, and they're very helpful. These are motions that you can make prior to trial. Of course, you can make motions in limine during the proceedings, but you can make them just prior to trial and sometimes even during trial. And they're usually evidentiary motions, something that you didn't expect to come up, a discovery or an evidence issue you didn't anticipate. You can make that motion. I've had attorneys make motions to disqualify experts because they didn't like their opinions. Those are very interesting fights to have. They know there's an evidentiary issue, something they don't want to have come in. They may make a motion. Motions to quash, preclude, eliminate, they're all just procedural motions throughout the case that help you make sure your evidence is solid and your case goes in as easy as possible. And 2 minutes, any questions? Right. Wait, let her have the mic.
In another state, we used to do motions in limine all the time to keep out the experts, and there are criteria showing why somebody should be qualified and why they aren't. And here, I found that nobody ever, or at least in my county, nobody ever files them. And when I say, can we file one, they go, what?
Well, I tell you, in 30 years, I've had one filed. I didn't file it; it was filed. And as long as the person is an expert, what they were really arguing about was that they didn't feel that this particular expert followed appropriate procedure for a child custody evaluation, because as you know, there's all procedures out there. And what the courts tend to do is say, we're going to let the expert testify, we're just going to weigh the opinion, you'll have your chance to cross-examine and chop away at it. So I think the reason you don't see them a lot with experts is if they are truly experts and they're going to get in as experts, what they're really objecting to is the opinion, and that can be better addressed at trial. Thank you. You've been a great audience.
Thanks very much, Barb.